Good afternoon, everyone. I almost said good morning, so good afternoon. I hope you all are staying dry and staying out of the wind. I know it was quite the event on the west coast of Florida and even over on the east coast up in the Indian River County area where one of our offices is. My name is John Carrogan. I'm with the law firm of Ross, Earle Bonan Ensor. I'm going to attempt to share my screen here. Can everybody go ahead and see that?
We can see it.
Perfect.
Thank you.
So we got the presentation online. That's step one. The rest of it should fly by. So the purpose of today's presentation is because you are new condominium board members. And this is a board certification course. In 2017 or 2018, the Florida legislature required new board members to do one of two things when they came onto the board. One is review all the governing documents and execute a document stating that you've read them and will faithfully uphold your duties as a director. Or number two, to go out and get educated through a board certification course. And that is the other element in one of the ways that you can satisfy the statute. So this is the statute 718.112 2D4B. As we go through the condominium statute today, you're going to see a lot of references to very particular portions of the statute. Do not worry. Do not think, oh, I missed that. At the end of the presentation, we put all of our presentations in PDF format. So you can email Brenda and Kevin and the team at Vesta, and they will go ahead and get you a PDF copy of the entire presentation. It's also my understanding that they will put this on their website, at least for a period of time, where you can go back and review particular topics that I went ahead and spoke on and opined on a little beyond what's in the PowerPoint presentation itself. So this is the statute I was referencing. Within 90 days, you have to either execute the self-certification form or, in the alternative, attend a certification course. When you get done with today's course, we will get a list that provides everybody who attended and their email address via Zoom. We will then prepare a certification certificate, and we will email that to you, or Brenda's team will email that to you. Take that certificate and put it in the official records of the association so that when you are elected to the board, or if you already are on the board, they are aware that you have this certification already completed and don't have to worry about it. So a director, what happens if you don't do one of these very two simple tasks? Well, a director who fails to timely file a written certification is suspended automatically on the 91st day after the election. So we don't want to run into that situation. If you're running up on the 90-day deadline and you don't have the certificate from us, execute the self-certification form. Your management company should have a copy of that. It's a DBPR form, the Division of Professional Regulations, the form they procure. You can execute that, put that in the official records, know you're set, you don't have to worry. And then when the certificate comes in, at that point in time, you will then go ahead and be able to also certify that you have been board certified. So with that being said, the topics today that we're going to touch on: condominium budgets and reserves, money coming in, money going out, and how do we go ahead and account for that, and what are the statutory requirements? Elections. Elections are statutory driven in the condominium world, unlike the HOA world. So we'll talk about what does the statute require when it comes to elections. We'll talk about official records. What are those, and what do you have to do if you get a request to produce official records? And then last and finally, we'll end up on covenant enforcement matters. Think of those not only as violations that homeowners engage in, and how do we attempt to resolve those as effectively, cost efficiently as possible, but if a homeowner brings a claim against the association, what do we do? And so we'll touch on those topics. Brief statutory update at the very end with the latest and greatest updates in this last legislative session, and then we will go ahead and be done. If anybody sees up in the right-hand corner, you'll see the number 5 on this slide. There are 83 slides. Do not worry. We're not going to spend a ton of time on each one. I think about an hour and 15 minutes is the runtime on this presentation. And then, of course, as Kevin mentioned, there's the Q&A box. If you have any questions, I will stick around at the end. I will answer all the questions that are asked to the extent I can. So don't feel that I'm not selecting you for some reason during the course of the presentation. I just want to get through this so people can go and get on with their day. And if you want to stick around, free legal advice, why not take it? So before we jump into condominium budgets and reserves, let's talk about the structure of what a condominium or cooperative association is. They are one, a not-for-profit corporation under Florida law, governed by Chapter 617. Not-for-profit corporations include condominiums, HOAs, cooperatives. They also include what you would think of as standard not-for-profit corporations, healthcare providers, organizational charities and stuff like that. But they're all governed by Chapter 617 and really govern as to the governance, the board of directors, the officers, what can they or can they not do, what are their powers, and so forth. You're also governed by the real property section of the Florida statutes, Chapter 718 for condominiums, Chapter 719 for cooperatives. So if you go ahead and have a question come up, you want to look towards Chapter 718. If you're a condominium, that may answer your question. You also want to take a look at your governing documents. The governing documents of each condominium association is going to consist of a declaration of condominium that may be amended from time to time. So make sure you have all the amendments when you're looking for an answer. It's going to have a copy of your bylaws. Your bylaws are the day-to-day governance for the board of directors. How do we conduct an election? How do we go ahead and have a board meeting? How do we properly notice our members' meetings? How do we go and establish a budget? Those kind of operational aspects. You're going to have an article of incorporation, which sets up the not-for-profit corporation and may outline the powers of the association. And then you may have subordinate governing documents such as rules and regulations. You may have ARC or ARB standards. So those depend on each particular community, but you're at least going to have the declaration, the bylaws, and the articles of incorporation for your community. What that means is when you come with a legal question, the first person you should go to is go to your manager, go to your management company, go to Vesta, and ask them and say, hey, we have this issue. What are your thoughts on it? Most of the time, good management companies like Vesta will be able to give you a quick answer because one, they know the history of your community and the issues come up before, or number two, they're so experienced in the field of condominium law that they understand when this comes up, it means this. For example, an election question. For example, the collection of delinquent assessments, a violation, and so forth. Vesta in particular does an excellent job of knowing when they should not be answering a question, but really should have legal counsel opine on it, either because it calls for an interpretation of the statute or governing documents. It's not abundantly clear on its face, so they need an attorney to opine to it. Or number two, they understand that there's some risk assessment associated with the analysis. And that's really where your lawyer goes ahead and comes in with the vast experience to say, in these types of situations, these are the considerations. The board should take the input of the manager and the management company, the input of the lawyer if necessary, and then make a sound business decision to resolve that particular issue. So that is the framework in which condominiums and cooperatives operate, the governing documents and the resources that you all have when it comes to addressing concerns of the community. So let's jump into the first topic, condominium budgets and reserves. So a budget is the map that will guide the board in making decisions during the course of the year. It is the board's formal written plan of the association's estimated future expenses. So understand that one, a budget is only a plan. Very, very rarely does the budget end up being what the actual revenue and expenditures are, because there's always items that come up throughout the year. There's people who don't pay their assessments, but it's a plan. So going into 2023, your board in September and October and November should be developing its budget, its plan for revenue and expenses for the upcoming year. How do we go ahead and adopt a budget? Well, a budget has to be adopted at a budget meeting. This is controlled by statute, not by your governing documents. The condominium statute, for the most part, supersedes many portions of your governing documents when it comes to budgets, when it comes to elections, when it comes to insurance requirements. Regardless of what your condominium documents say, you should start by looking at the statute itself. In this case, adopting a budget requires a budget meeting of the board of directors. It has to be mailed, delivered, electronically transmitted, not less than 14 days prior to that board meeting. Importantly, within that package that's mailed to the homeowners, you must include a copy of the proposed budget, the actual budget sheet that shows here's how much we're going to spend on landscaping, management fee, legal fee, administrative, and so forth, reserves. All of that has to go and be in there. Also, when you're developing your budget that's mailed out to owners, you must realize that reserves, those categories, and we'll talk about what those are, have to be fully funded. You can't partially fund, you can't try to waive reserves in the board's initial budget. That's something you have to go to the membership and get permission to go ahead and do. So adoption of the budget has to be 14 days prior to the start of the fiscal year. Most clients, if they're on a January 1st to December 31st, are adopting their budgets in October, November, or hopefully early December. Because if we don't do it by early December, then you can go ahead and get in trouble with the DBPR, Division of Condominiums. That's the governmental agency that oversees condominiums. They can levy fines. They can go ahead and apply for receivership if it's egregious enough, something we just don't want to run into and have those self-inflicted harms. Also, unless the documents call for a unit owner to adopt the budget, the board must adopt the budget with fully funded reserves, unless those reserves have been properly waived. We'll get into how that's done in a second, but understand that under most associations, it is the board who adopts the budget. Only if your bylaws or declaration provide the membership adopts the budget would that go ahead and apply. So check your governing documents. I can think of, we represent about 700 community associations. Let's assume that at least half of them are condominiums. I can think of only one or two clients where the membership has input as to the development of the budget itself. So most likely in your community, it would be the board. Recall that the budget that's proposed, the notice and the affidavit of mailing are all official records of the association. So you need to go ahead and keep a copy of that in case anybody ever wants to look at it and see what you sent out and the notice was properly provided. So let's talk about operating budget requirements. There's two elements to a good budget. Number one is going to be your operating costs. Those are costs that are incurred throughout the course of a year to take care of the expenses of the association, and there's going to be reserve. This right here will only talk about the operating. Assessments, interest, insurance proceeds, and any other revenue. That is the money coming into the association. That money coming in needs to equate to the money that is budgeted to go out, and that is how we calculate the end of the day assessment for individual units. Operating budgets must include your expenses, the annual condominium fees paid to the state. So if you didn't know, each condominium is required to pay $4 per door to the state of Florida every year to pay and fund for the DBPR Division of Condominium in oversight as it pertains to that. You must include insurance and fidelity bonding as an expense, and it must also include administration, management, maintenance, rent for recreational facilities, if you have them, taxes, and security provisions. So these are items that are generally included within a budget, but each individual community will have its own unique features. It may be more, it may be less. If anybody would like to dive into, well, what goes in a budget farther, if you search DBPR budget on Google, the first return you'll get is about an 80-page document that was prepared by the Division of Condominiums that gives you a line by line, here's how you prepare a budget, here's what goes into a budget, here's how a budget is adopted. So very lengthy document, much more detailed than I'm going to get into in this presentation, but a great resource if you need help in preparing the budget. And obviously when you're preparing the budget, rely on the professional advice of your management company. The attorney really never gets involved in that process, but the management company has seen it. They will give you the template to start that process. Other requirements under the budget, you have to have the beginning and ending dates for the budgetary period. Most clients are on January 1st to December 31st, but occasionally we'll get a client that's on a July 1st to June 30th, or perhaps some other one. So always take a look at your bylaws to determine if it's anything different than January through December. It must include total expenses, including reserves on at least an annual basis, and assessments per unit according to proportional ownership, not less frequently than quarterly. So that is, do we levy on a monthly basis? Do we levy on a quarterly basis? That is the type of items we're looking at. And then also in a condominium, realize that assessments by statute have to be shared equally amongst the units. So 100 unit, everybody pays 1/100th, but for the exception, if your governing documents provide the assessments to be broken up by proportional footage of the units. And sometimes we'll deal with high-rise condominiums that have a penthouse on top, and the developer felt that that condominium should pay a little bit more than everyone else. And as a result, instead of an equal division of the budgetary amount that needs to be paid, it's on a percentage of ownership interest. And that will be provided typically in an exhibit to your governing documents. The 115% rule, very important rule. If you receive a petition from your members to put in a substitute budget, very important you pick up the phone and call legal counsel. We will walk you through this process. It is a very arduous process for the homeowners to force an amended budget in place to supersede the board's adopted budget. I've only happened once, maybe twice in a 13-year career practicing in this area. A lot of procedural hurdles they have to go through, but it's very important that the association, in addressing the substitute budget that the members want to go to put in place, doesn't misstep and end up in arbitration where they determine the members didn't meet their burden, but at the end of the day, the association did a misstep. And as a result, we have to go back and redo everything from the very beginning. So the only time this can apply is if assessments are greater than 115% of the prior year, and then the owners can petition the board to adopt a substitute or alternative budget. To determine if you've exceeded this 115% rule, you go from the total budget assessment, subtract those portions from reserve, expenses not anticipated to be incurred on an annual basis, and betterments to the condominium property. So importantly, if you have to bump up your reserves to address, for example, the new Surfside legislation and the increase in engineering fees and work that has to be done under that, that does not impact the 115% rule. The 115% rule realistically only would apply to 115% increase in your operating budget year over year. I always recommend to clients, once the budget's prepared, do the math yourselves. Understand if you're over the 115 or not. If you're under it, we don't need to worry. And if we're over it, then what's our plan of action if we do get a challenge? If the net assessments are still more than 115%, then here's the process. So 10% of the unit owners must apply to the board to consider an alternative budget. They only have 21 days from the board's budget meeting. A meeting must then be held, a membership meeting, within 60 days after the adoption of the board adopted budget. And at least 14 days prior to that membership meeting, the board must hand deliver or mail to each unit owner a notice of the meeting. If a majority of all the voting interests vote to approve the alternative budget proposed by either the board or the membership of the association, that's how it passes. That's how the alternative budget comes into play. If you don't get a majority of all the voting interests, the substitute or alternative budget fails. And as a result, the board adopted budget will continue in effect. Now let's talk about, we talked about operating, let's talk about condominium reserves. Importantly, regardless of what your governing documents state, you are now required, pursuant to Florida law, to have reserves and to fund reserves. And you're not allowed to go ahead, at least based on the Surfside legislation, most condominiums are not allowed to waive reserves at this point moving forward. I keep mentioning the Surfside legislation. I should probably indicate what that is. So in July of 2022, the Florida legislature, during a special session, went ahead and adopted particular amendments to Chapter 718 that provided for mandatory non-waivable reserves for condominium associations. It also required that an engineer every so often come out and inspect the condominium property. The purpose of this legislation was in result as to the Champlain Towers down in, I think it was Fort Lauderdale, collapsing. The preeminence of that particular incident was that the association knew there was an issue. They could not get the funding for the project based on the reports that I've seen. And as a result, there was inaction on behalf of the board of directors. The legislature went ahead and took that matter under advisement and decided that in response it would require all condominium associations to now have mandatory non-waivable reserves. And for condominiums over 3 stories, there are particular additional requirements that are done every so often. I'm not going to jump into all of the technicalities. One, because there are some gaps in the statute itself. But number 2 is we expect the DVP, our Division of Condominiums, to come out with some administrative guidance very, very shortly that will bring more clarity to the legislation. And I don't want to give an opinion that will subsequently be incorrect if the administrative agencies come out and opine otherwise. But let's jump back to condominium reserves. So a reserve is any funds other than operating funds, which are restricted or for deferred maintenance and capital expenditures, including the items required by the Condominium Act, and any other funds restricted to use by the condominium documents or the association. So these are restricted funds. They can be only used for certain things. If we fall short and don't have a good budget, and we have a lot of operational expenses, we cannot dip into these reserves to go ahead and fund a shortfall in the operating. And that's the real key here is it's the rainy day fund, but it's in a safe, and you have to have the key to be able to access it. Capital expenditure is an expenditure for funds for the purchase or replacement of an existing asset whose useful life is greater than 1 year, and in addition to an asset that extends the useful life of the previous existing asset. Deferred maintenance is what you would think. It would be roadways, it would be repainting, it would be the roof on the condominium building, those types of things. Importantly, they're not required for yearly end of useful life replacement. That's the biggest distinguishment. You can have in your operating budget roof repairs, right? That's okay. But you need to go ahead and reserve for the end of the useful life, the full replacement cost of the roof itself. And that's what would be in the reserve section. Requirements regarding reserves. They must include, these are the categories that are mandatory by law: roof replacement, building repainting, pavement resurfacing, and any other item of deferred maintenance or capital expenditure exceeding $10,000. The Surfside legislation expanded this list quite significantly. But again, we're waiting for the administrative guidance before officially coming out with the list of here's the things you have to do. And know that Surfside legislation does not take effect until I think January 1st of 2024. Requirements regarding reserves. Reserves must include in the proposed annual budget and shall not be waived or reduced prior to the mailing to the unit owners of a proposed budget. Again, under the Surfside legislation, there's likely you cannot waive those anymore. And the reserve schedule must be included within the proposed budget. So typically what you'll see is you'll see a budget, and there'll be an extra page that explains all the reserve schedules, and we'll get to what example that looks like, a narrative. Here's why we're saving for this, and here's the amounts we came up with for it. The reserve calculation, here's the items you need to know. I'm going to go through an example that explains all this, but understand that these are the 4 categories that we look at when creating the spreadsheet. And when we talk about reserves, there are 2 different ways to go ahead and calculate reserves. One is a straight line method formula, right? So think of that as the different buckets: roofs, painting, roadway, any other expenditure over $10,000 in deferred maintenance or capital. Those are different buckets. And every year we put some money in this bucket, and then money in this bucket, and money in this bucket. Well, there's also another way, which we'll get to, which is called a pooled reserve, which we put money in a giant bucket that is accessible if any of the items come due. But for right now, let's stick with the straight line method, which is at least the 4 different buckets. And you look at the anticipated replacement cost less the beginning balance in reserve fund equals the reserves needed, and the remaining years left divided by the remaining useful life. So let's get into a chart that will kind of show you how this is practically applied. So you can see here that let's start with roof replacement. This reserve schedule shows that the estimated useful life of my roof is 12 years. It shows me I have 1 year left, meaning that we are in year 11 of our 12-year roof. Here is the replacement cost for that roof. And here is the funding balance that we have on hand today. So we know we have 1 year left. We know we have to get from 87 to 95. How much do we need this year? $8,000. pretty simplistic, straightforward math as we go through it, even for an attorney. When you get to the end of the day, you use this number down here, the 36,312. That tells you how much overall we have to put in reserves for this upcoming budgetary year. And this says that I have to do 8,000 for roofs, pavement 3,500, building painting 18,000, down the column. At the end of the day, we take the 36,312 and you divide by the number of units. If you do in everybody pays equal assessments, or you go ahead and multiply by the percentage of ownership if you do proportionally assessments based on square footage of the units. Pooled reserves, a little different. So straight line reserves are mathematically easy, but they're limiting in the fact that, well, what happens if we jump back to this chart? What happens if my pavement resurfacing, I have an 18-year life and I'm on year 7. What if year 10, the roads have to be redone, right? There's some catastrophic event, or the product that was put on wasn't properly done or didn't have the lifespan we thought, and it comes due early. Well, in the case of a straight line reserve, that we don't have enough money. We'll be well short of the $55,000 we need. A pooled reserve, instead of having the individual buckets where we put money in each year, is one collective bucket that we dump all the money into. It gives what I would term more flexibility to the board of directors. If something comes due early, whether it's because the product fails early or we have a catastrophic event, we can reach into the totality of the pool to pull out the money to fix that issue today. And then when it comes to the next budgetary year, we need to recalibrate our pool in its totality. But at least I have the money today and I don't have to go get a loan and I don't have to go specially assess my homeowners. So in a pooled example, jumping back to this chart, this is the estimated fund balance as of the end of the year that we were heading into, right? If we were in a straight line methodology, right, we had 87 for roofs, 30 for pavement resurfacing, 19 for building painting. If one of those came due early, my only options are to go get a membership vote to move some money around, or to go get a loan or specially assess. None of them are a great situation. If I have a pooled reserve, right, I have access to $206,000 immediately to fix the problem because it's one pool where all of my money is going into. The benefit to this is I can fix the problem. I'm going to have to recalibrate. I'm likely going to have to increase assessments because something didn't have the lifespan it was supposed to. So there is some makeup on the back end, but I know today I can access that money. I don't have to go to the members. I can immediately address the issue. So I recommend to most clients, the pooled reserve is probably the best methodology because you never know what's going to come up and what is going to be needed. But again, the downside to that is you typically need a CPA to assist you in recalibrating that every year. And there is some expense associated with that. The pooled methodology, we kind of just went through it, but you can certainly go through slides 24 and 25 if you want to get a breakdown of the math. But just understand at the end of the day, what it means is I have access to all the funds for all of my reserves to take care of any of the items within that pool if they come due during the course of the year. So let's talk about use of funds. Use of reserve funds and any interest accruing thereon must remain in the reserve account and shall only be used for those authorized expenditures unless it is approved in advance by a membership vote. Commingling. So most associations, when you send out your assessments or you do the ACH debits, you don't debit X for operating and X for reserves, right? It's just one deduction, $1,500 for this quarter for my condominium on the beach, right? Well, the association has 30 days after those funds come into its bank accounts to separate into a separate bank account that portion of that assessment payment, which is allocated to reserves. It has to be deposited in that different bank account. Failure to do so can result in sanctions from the DBPR. And expense categories that are not restricted shall be stated in the operating portion. So you cannot have a rainy day fund in your reserve schedule, although that would be nice. You can't have miscellaneous expenditures or deferred maintenance expenditures. It has to be allocated towards a particular item. This slide always brings up the question, John, can we have a hurricane fund, right? Because when a hurricane comes through, we're going to have hurricane deductible, we're going to have maintenance people have to come out, and that's an expense that we don't want to put in our operating because we don't know if we're going to incur it this year. The answer to that, in my opinion, and it's just my opinion, is if you describe the purpose of the hurricane fund, it's to pay an insurance deductible, it's to pay for emergency repairs post-hurricane, I think you are permitted to go ahead and do that and have that as a reserve category. But you cannot just have a slush fund or a rainy day fund. The statute is very clear on that. And reserves not required by statute. So if you want to reserve for items that are not over that $10,000 deferred maintenance or capital expenditure, you do not have to use the statutory formula, but you have to attach it in a separate reserve section of the budget, not the statutorily required reserve section. Now, I'm going to go over some things about waiving of reserves. Understand that in the wake of the Surfside legislation, not a whole lot of flexibility here to go to waive anymore. Again, we'll wait for that guidance to come out to confirm that waiving reserves is no longer going to be permissible. All right, so that brings us to the end of reserves and budgeting. That is how the money comes in, the money goes out. Realistically, the attorney is not really the person to go to on that. That would be your management company, and they will walk you through that process. Certainly, if you run into a 115% rule challenge or want to talk about the ability to waive reserves with this new legislation, that is something that you should talk to legal counsel about. So let's jump next to condominium elections, statutes and rules. So every association in your bylaws is going to have an election process. Understand that that has been superseded by statute. So Florida statute 718.112.2D is going to be where you're going to look for election procedure, and also FAC rule 61B 23.0021. That is the Florida Administrative Code. All that does is that puts more meat on the bones when it comes to the statutory process and deals with some nuances when it comes to the double envelope balloting system. Let's talk about candidate eligibility. You must be eligible to serve on the board at the time the deadline for submitting the notice of intent to run. And we'll get what those deadlines are, but no, it's 40 days prior to the election. Not eligible if you are delinquent in the payment of any assessment to the association, right? So call the management company, make sure you're current. We don't want to have any delinquency resulting in you not qualifying for the board. No felony convictions unless your civil rights have been restored. It does not give you the permission to run a background check on all candidates, but if there is cognizable evidence that somebody running for the board does have a felony, contact legal counsel and they'll walk you through the options to determine whether that is accurate or not. And in an association of more than 10 units, co-owners of the unit may not serve on the board at the same time unless they own more than one unit. So if me and my wife own one single unit in a 12-unit condo or 50-unit condo on the beach, we are not both running for the board of directors. But if you're under 10, you can certainly do so. Term limits. So importantly, this came out in the legislation from 2018. Understand that you now, as a board member in a condominium, have 8 years on your term on the board of directors, 8 consecutive years. So if you come off in that 8-year period, you do not run into a term limit issue. If you stay on the board that entire time, once you get to your 8th year, in order to remain on the board, you have to get 2/3 of all votes cast in the election. So if you're very popular, not an issue. You can continue every year thereafter, so long as you get that threshold. But as you know, if you're not reaching your term limit, it's a plurality vote, and the highest number of vote getters based on the number of seats is elected. So if you're reaching up that 8 years, that's something to look out for. There was recent guidance issued by the Division of Condominiums, which said that 8 years starts from the effective date of the statute when we calculate it. So statute went into effect July 1st of 2018. So I'm going to do some quick math. I think that puts us at 2025, 2026, where we will even have to worry about this. So if you served on the board before 2018 and you've continued on, you don't need to worry about it at this point in time. It's only once we hit 8 years from July 1st of 2018 that we're going to have to start considering the implications of this term limit. So elections, the procedure on the night of the election, understand that an election is held parallel to, but is technically a separate event from the annual members meeting. So it's held during the course of it, but it is separate. And so when you conduct an election at your annual members meeting, it is the first item of business that you address before you get to the president's report, the treasurer's report, or anything else. The election is not required if the number of vacancies equals or exceeds the number of candidates. So if I have 5 open seats and only 5 people put their name in the hat, I do not have to have an election. Those 5 people will take their seats at the conclusion of the annual meeting. They will be your new board of directors. A lot of clients like that provision of the statute because they don't want to have to do the whole mailing process if it can be avoided. And so if you have equal to or less than the number of candidates, you don't have to send out the election material. In order for an election to be valid, at least 20% of the eligible voters must cast ballots. If you do not get that, it needs to be adjourned. And you must have additional blank ballots and envelopes available at the election for people that did not return their ballot in the mail. And importantly, over the last couple of years, there's now a third-degree felony. So there's a criminal penalty if someone forges a ballot or a voting certificate. So not that that would ever happen to any of our clients, but it is something that is out there now. I'm not aware of anybody ever being convicted of that crime at this point, but we will certainly keep a watchful eye. So let's talk about election deadlines. In the condominium world, this is uniform. It does not matter what your governing documents say, the statute controls. 60 days, at least 60 days prior to your annual meeting, a first notice of election goes out. That is the document that says, hey, we're having an election, an annual meeting on this date and time. If you want to put your name in the hat, please do so. That's basically all it says. 40 days prior to the election, the notice of intent to run has to be turned in by anybody wanting to run for the board. So that's essentially the cutoff to determine who is going to run for the board of directors. If you turn it in on the 39th day, does not count. The case law is very, very strict on that. My recommendation is always, if you're going to turn it in, get a receipt, the association acknowledging they received it, send it via email, return receipt requested, so you know that they received it, but get it timely to the association well in advance of the 40-day deadline so that legal doesn't have to get involved and tell people why they are not eligible. 35 days prior, you need to submit your candidate information sheet. Think of this as your CV or your one-page resume. The association has no control over what is on that document. Most of the time, it includes a person's resume. Here's my professional experience. Here's what I'm going to do when I'm on the board. But the association should not be looking at the substance of that. All they do is say, is it on an 8.5 by 11 piece of paper? Yes, it is. I don't care how small the writing is. I don't care what it says. That's what gets mailed out to the membership. And then 14 days, at least 14 days prior to the annual meeting election, the second notice goes out, which includes a copy of the agenda, which includes a notice, which includes the double envelope. We'll get into that in a second, what that is. But it has everything you would need to cast your vote at the upcoming meeting. Many management companies are very good in sending out that second notice in advance of the 14-day deadline. So they'll send it out. It has to be less than 34. I'm sorry, yes, less than 34, but more than 14. So they'll send it like 20, 25 days before the meeting, just so we don't run into any deadline issues. So we talked about the 60-day notice. That's the notice that goes out to the members. We're having an annual election. Typically, it includes the notice of intent to run form, which identifies how people can put their name in the hat. The 40-day notice is the cutoff. 35 days is the candidate information sheet. That candidate information sheet is distributed with the second notice of mailing. I think that's very important. And again, you cannot edit, alter, or otherwise modify the content of the sheet. We are very neutral in what people put in there. We just mail it out as is. And then the 14-day second notice is the real package, the mailing package, the absentee ballot that people can use to cast their vote in the election. So election ballots themselves. So these are the documents that are mailed out to members in the double envelope system, or extra copies at the annual meeting if somebody didn't already mail it in. You must list all eligible candidates in alphabetical order. I really dislike when I have to call a client and say, hey, we have to reschedule the annual election because we did not do it in alphabetical order by last name. A very stupid thing to trip on, but it happens. And the case law is very clear. The DBPR says if there's a challenge, we're going to make you redo it. So I always tell clients, let's not even go that route. Let's just redo it ourselves and voluntarily get in compliance. You cannot indicate whether people are incumbents. It's supposed to be content neutral, what's sent out. You cannot have write-in candidates because that 40-day cutoff defines who the eligible people are going to be. There's no space for a voter signature. Unlike in the HOA world, in the condo world, in the cooperative world, there is secrecy of the ballot. So people should not be putting their names on the ballots. And they must be a uniform color in appearance, except where there's different classes of voting, which is very unusual in a condominium. If you have that, you should be with legal counsel talking about what that requires. But most of the time, white sheet of paper put in the envelope or in the alternative at the meeting where people can go ahead and cast their votes. So let's talk about the double envelope system. Think of this as an absentee ballot that ensures the secrecy of the ballot and allows those people who are not going to be at the annual meeting in election to cast their ballot. There's an outer envelope and there is an inner envelope. And essentially the outer envelope is the equivalent of your proxy. It allows the management company to identify who is casting that vote. So when you get your second notice of annual meeting, there will be that outer envelope where you will sign, you will date, and you will mail back to the association. Here's what happens with the inner envelope. The inner envelope does not contain any markings, will contain the ballot. So when I get my double envelope system, I complete my ballot, I fill in the people I want to do, I don't mark anything else, just the people I want to vote for. I tri-fold it, I put it in the inner envelope. I lick it, I seal it. That inner envelope has no markings on it, right? It's simply there to go ahead and contain your ballot so that nobody can see it till it's open. That inner envelope is then put in the outer envelope. That outer envelope is sealed, you sign, you date, you mail back to the association. You've done everything you need to do as a homeowner. You have cast your ballot. And the alternative to that is to show up at the annual meeting and cast your ballot in person, which is a relatively simple thing, like when we vote in presidential elections or so forth. So once you complete the outer envelope, you put in the inner envelope. Eventually, everything is sealed and mailed back to the association, knowing that the outer envelope is identifiable, the inner envelope and ballot are not. And then let's talk about what happens at the meeting. So the first thing you have to do in a meeting is call for any uncollected ballots. So those would be people who have showed up in person that have a ballot. You go collect them. The second thing you do is you have this impartial committee appointed. They cannot be board members or their spouses or candidates or their spouses for obvious reasons. They're supposed to be impartial. That committee collects the uncast ballots, and then they go through the roster of owners to ensure that they have counted everyone who is in attendance at the meeting by looking at the outer envelope. When they identify the outer envelope, they identify John's outer envelope, they check my name off the list. That way, if they receive another outer envelope with John's name on it, they know that they don't have to count it because they're not allowed to vote twice. If there is any outer envelope that is unsigned that has a technical deficiency, it is marked disregarded, but it is kept as part of the official records of the association. So do not throw it away, but you write disregarded on it, and anything inside there is not counted. Once we go through and we identify all of the outer envelopes and everyone that has voted and collect all the ballots that have not yet been cast, we then, in front of the entire membership, not in a separate room, there's case law very clear on that, in front of the entire membership, We open the outer envelopes. We put them in one bin. We take the inner envelope, which has the ballot but no markings, and we put it in another bin. We do that for every single one of those until we have a bin of all the outer envelopes and a bin of all the inner envelopes. We put the outer envelope bin to the side. That's part of our election material. We keep that. We then go ahead and take the inner envelope, shuffle them up, and then we start opening the inner envelopes containing the ballots. Because we've separated outer from inner, there's no way to tell who John voted for in that inner envelope because we don't know which inner envelope is mine. That is the entire purpose of not marking up the ballot and not marking up the inner envelope. All of it has to be done in front of the membership. I get that call every year. We did it in a separate room because we didn't have the ability to do it in front of the membership. It was too packed. We couldn't hear each other. Does not matter. The DBPR will make you redo the election. Just do it in the same room. As soon as the first outer envelope is open, the polls are closed. Hence why it is so important to call for, are there any outstanding ballots? Make that announcement twice and then start the process. All envelopes and ballots, whether disregarded or not, must be retained for 1 year. And so the management company, I know Vesta does this very well, has their bins and make sure that everything is kept in safe storage for that 1 year. If anybody wants to go back and look at that documentation, it is easily producible. So this is the election flow chart. I'm not going to dive into deep detail because it goes over what I just went over, but know that on slide 45 in the PowerPoint presentation, very, very helpful in printing this and bringing this to your election. So that is elections, statutorily driven. If there are questions, get with your management company. If there are still questions or the manager believes there are ambiguities because something unique came up, talk to your attorney. Get their input ahead of the election. Many of the issues can be resolved. We can send out a revised second notice if we left someone off the ballot. We can fix it. But showing up the night of the meeting, knowing there's a deficiency, is probably the worst case scenario. And I've had to be there and tell the members, thank you for showing up. We will go through and we'll have the president's report and everything else, but we will not be conducting the election this night because there was some technical deficiency in the process leading up to it. So get with your legal counsel, get that timely done, and hopefully you will not run into an issue. Next, we're going to jump to condominium records, maintenance, and access. So these are official records of the association. They're controlled by 718, 11112, and the Florida Administrative Code 23.002. So the statute provides guidelines for the maintenance and inspection of records. The official records must be maintained within 45 miles and within the state of Florida, and except as otherwise provided below, they must be kept from the inception of the association. So there used to be a rule that after 7 years, you could start burning stuff. At this point in time, I'm recommending to condominium clients that we just keep everything. If we have very ancient documents, probably the best thing to do is have those scanned and then uploaded to the cloud so that we will never go ahead and lose them. So what are official records? I'm going to go through a list. I think it's 8, 9, 10, 11, 12 number of what are official records. I think it's good that you see them, but understand there's a catch-all. So unless I tell you otherwise, treat every record of the association like an official record. But of course, we'll talk about permits, warranties provided by the developer, copy of the declaration, books containing all the meeting minutes, both board and unit owner, pretty typical. Current roster of all unit owners, the mailing addresses, unit IDs, and voting certificates, and if known, their telephone numbers. It would include the email addresses and fax numbers for those that have consented to receive electronic notice. So if I've opted in to say, hey, don't mail me my annual meeting package or my notice of the board meeting, just email me. That is an official record, that document me opting in. Copy of all the insurance policies, copy of the management agreement, bills of sale for any personal property of the association. Number 8 is basically all financial records, bank statements, monthly cash flow statements, audits, and so forth. Ballots and sign-in sheets. So that's the election material. That's one of the exceptions to the keep it into perpetuity that only has to be kept for 1 year. All rental records of the association, where the association is acting as the rental agent. Most condominiums that we deal with, they do not rent out units on behalf of their members, but if you live in one of those condominiums, understand that is an official record. And a copy of the FAQ sheet required by 718-504, which is provided to purchasers in the community. And so this is the catch-all, number 12, all other written documents related to the operation of the association. So when we go in and the DBPR is investigating one of our clients, and they say, well, do you have this document? My client says, well, that's not one of the ones listed. They always point to this and say, yeah, but it's any other written record. So that's why it's better to look at official records from the perspective that treat everything like an official record. And then I will go through the list of exceptions. But here's some examples of stuff that we went ahead and took a look at. Bids for materials, invoices for purchases made by the association. These are the fall within the catch-all that some of our clients have been caught with because they didn't believe that it was an official record because it wasn't specifically enumerated. Turns out the DBPR thinks otherwise, and so we like to point these out to clients. The association must provide, without charge, a copy of the most recent financial report. So that year-end financial report, after you have to go ahead and provide it to your members or provide notice that it's ready. A lot of clients will go ahead and send it out and give a link where it can be downloaded. But if somebody wants a hard copy, you have 5 days to do it. If you do not provide them a hard copy free of charge, there are sanctions the DBPR can seek against the association. A unit owner may provide written notice to the division of the association's failure to mail and hand deliver a copy of the financial report. That's the penalty. And the association shall provide an annual report to the department containing the name of all financial institutions in which it does business. This is something the management company should handle for you. But if you are for some reason self-managed, or you know it has not been done by your management company, you need to get that information to the division to ensure you don't get subject to some statutory penalty, and a copy of the turnover inspection report if available. So this is the flip side of the coin. What is not subject to official records? So I'm going to go through all these. Obviously, one of them is attorney-client privilege communication. I also want to jump in and identify, based on recent declaratory opinions from the DBPR, director-to-director email addresses. So from John Carrogan's email address as a director of XYZ condominium to another director's email address is not part of the official records. The law is very clear on that. If you have a general email address, xyzcondominium@gmail.com, where people can send their complaints or criticisms or requests for items in the community to be taken care of, recent declaratory statement came out and said that is official record. And if a homeowner sends you a request and then you respond through that xyzcondominium@gmail.com, that is also subject to official records. So understand, board member to board member, not official records, general email address, copying the manager on a director-to-director communication now becomes official record. So we have to be very nuanced about who we're communicating with. A lot of times I'll have directors that will discuss and try to draw up a consensus amongst themselves on a particular issue. And then once they have that consensus, they'll loop in the property manager because they know that it's been created an official record. Understand that just because something is not an official record, it can still be subpoenaed. So we always live with attorneys that if I have great news, I'm happy to put it in writing for you. If I have bad news, I'm going to pick up the phone and call you. And I think that applies equally to its governance of the association, because at the end of the day, everything is subject to the power of subpoena if it exists in writing. So other official records or items that are not official records, attorney-client privilege communication. That's pretty simple. I think that's very apparent, protected under statute 92.502, Florida statutes. Certain information obtained in the connection of the approval and lease or sale of homes. So that would go to be the background check or the credit check if you run those on your lessees or purchasers in the community. Those are not official records. Medical records of unit owners. So those would go ahead and be, if you receive a doctor's letter as part of a fair housing accommodation, That healthcare provider letter itself, medical documentation to support the need for an assistance animal, all of that is not official record and protected by medical privacy laws. Personnel records of the association and management company. So this does include the manager's FICA, right, statement attached to their paycheck, payroll, health insurance records, stuff like that, not accessible to the members. However, the management agreement itself, a copy of checks which show how much was paid to the manager or management company, all of that official records. Social security numbers, driver's license numbers, credit card numbers, email addresses, telephone numbers, emergency contact information. Those are all personal identifying information which are not subject to official records inspection. That being said, if those people fill out that opt-in form for electronic notices, that is accepted. So couldn't make it any more confusing from a legislative perspective, but that is the rule. Electronic security measures and software used by the association. So somebody can't make an official request for all passwords of all owners to access the association website, right? Those types of things. And if you use QuickBooks, Excel, or something else and have a license, a homeowner is not entitled to access that software by virtue of being an owner. So the inspection of records, the associations must be open to all members or members' authorized representatives at reasonable times, meaning you can't make the records inspection at midnight, just so you know. Typically business hours is considered reasonable times. It must be made available for inspection within 10 working days. So if I receive a request for inspection, and I gave this example in another seminar, for the financial audit for 2020, 2019, and 2018 at my condominium association. If it's easily accessible, a lot of times I'll tell a client, send them a link to download it from the cloud or pull it down yourself and email it to this homeowner. Very simple, very easy to go ahead and provide specific records that an owner is requesting. When you run into the more broader requests, all violation letters in 2020, all financial records for the past 7 years, it becomes very difficult to go ahead and say, well, what exactly does the owner want out of this? So you can always pick up the phone and call them and say, hey, is there anything specific you can look for? But a lot of times you get the homeowner that says, no, I want everything. Great. Well, you can't really send them a link, right? Because we might miss something. So what I recommend in those instances is set a meeting within the 10 working days, have them come in and have them look through the banker boxes. And tell them again, if you need something specific, I'm happy to assist you and pull that specific document so you can look at it. But if you want to look at everything, here is everything. That's the best way to ensure compliance with the statute. And obviously you can make it available electronically. One of the things that I always recommend to clients is establish a record of you handling the records request. If somebody eventually goes after the association, accuses you of failing to comply, it's very hard to rely on testimony. Well, we think we got it this date, and I know I called them and told them that it would be available this date. Not good. Not good from an attorney perspective. What I recommend is you receive an official records request, immediately write back to the owner acknowledging the request, 1, and 2, identifying the date and time where the records inspection will take place, or respond back with the documents they're requesting. Again, specific documents, easily accessible, send to them. More broad documents, great, come in. We'll do it, next Thursday at 9 a.m. in the association office. And understand that when you make them available for inspection, it does not mean you're making copies for them yet. They have to request them. It just means that you need to lay them out on the table and take a look at everything. And they have the opportunity to look at them, review them, and request copies or take pictures on their phone. One of the best tools we run into with an association and a homeowner is abusing the records request statute is adopting reasonable rules and regulations regarding records requests. The division has come back and said, you can adopt a restriction that limits records requests to no more than 1 per month and no more than 8 hours in a business day. So if you have a homeowner who likes to go home at night and be a keyboard warrior and send you 14 records requests, absolutely fine if you have a rule in place, because we will handle 1 in September, 1 in October, the next one in November, and we'll just stretch this out into perpetuity. But if you don't have those types of rules in place, adopted at a board meeting, these types of rules have to be adopted at a board meeting, then you have to respond to each and separate request within that 10 business day period. So it's a great way to shield and protect the association and manager's time by adopting reasonable rules and regulations. Certainly, if you're a client of our firm, we have a standard recommended rule that we provide to our clients. I'm sure that if you're not with our firm, but with Vesta, I'm sure that whatever counsel you have could certainly provide you with a template of something to adopt that is in compliance with the division rules, but at the same time creates hurdles for somebody that's abusing the system. So let's talk about copies. So the owner comes in, they want all financial records for the past 7 years. Well, that's a lot of documents, right? So we put them all in banker boxes. We got them out of storage. We bring them into the office and say, here you go. Go ahead. You can inspect them, right? They have the right to request copies. So what I generally do in the records inspection is I hand them a little sticky tab thing, like one of these, and I say, anything you want copied, not a problem. We're going to charge you for the cost of it, but mark it. And then when you're done, we'll go ahead and have it sent out for copy. If it's under 25 pages, I generally recommend if you have an in-house copier, just get it done and get them the copies and charge them a reasonable fee for it. If it's over 25 pages, they want a copy of the 300-page insurance policy. Great, right? We're going to send that to Kinko's or FedEx or whatever the current vendor is. They're going to charge whatever they charge. They're going to give us a bill. They're going to give us the copies, and we'll tell the homeowner, hey, your copies are ready when you pay this bill. And they got to come in with a check for $60, $100, $200. And when they give me the check, I'll give them the records. You cannot charge a fee for inspecting the records, but again, you can charge the reasonable cost of copying. I always get the question, well, what's a reasonable cost, John? The HOA statute says 25 cents per page. So I think that's a pretty fair standard that we can rely on the HOA statute's guidance for what is reasonable. Members can use their own technology. So if they want to bring in an iPad, an iPhone, an Android device, and take pictures with their phone, cannot charge them for it, cannot stop them from doing it. So let's talk about failing to provide access to records. Well, one, any of my clients should never run into this issue, because when you got the records request, you went ahead and responded, acknowledging it, stating the date and time that the records inspection would take place, and we showed up and we provided the records. But if you do fail to provide, you just missed the deadline, whatever it may be, these can be the consequences, and they're pretty severe, right? So a failure to provide access within 10 working days after the receipt of a written request, which would include email, creates a rebuttable presumption that you've willfully complied with the law. The owner is entitled to damages of $50 per day up to a maximum of $500. Well, I always get, well, John, $500 isn't so bad. Well, guess what? Then they go and make a demand for statutory pre-suit mediation, which is a condition precedent to filing a lawsuit to collect that $500. Well, the mediator is $1,000, plus you get a legal counsel there. And then they sue you in small claims court, and you got to pay for a defense of that. And if the court determines that you did not provide access and that the owner prevails, you could end up paying their legal fees. So this $500 charge turns into thousands and thousands of dollars in legal fees. And that can all be avoided by, one, timely responding and putting your responses in writing. That positions me that if they go out and make a frivolous claim that we failed to respond or failed to provide them access, I have the documentation to rebut that. It makes it a much stronger case and allows me to create risk on the homeowner side that maybe they don't want to pursue this, because guess what? They sue you in small claims and they lose. The court could say, Mr. So-and-so, not only do you not get your $500, not only do you not get your attorney fees reimbursed, but now you're paying John's attorney fees as part of this. So, but again, I can only position my clients to take that if they set themselves up to be successful. All right, we're on to our very last section, thankfully, before we get to the statutory update, condominium dispute resolution. So we're going to jump into two aspects of this. One is from a violation standpoint, right? They're parking a truck and we're a no truck community, something like that, violation of the use restriction. And then what do we do if the association, a claim is brought against the association? Let's start with the easier one. somebody decides they want to sue the association, right? Well, very rarely can they go out and just sue the association. Typically, they have to make a demand for pre-suit mediation if it relates to some non-compliance with the governing documents, or they have to file a petition for arbitration before the DBPR. So going straight to a lawsuit is very, very difficult. But if you receive a demand, right, threatening litigation, threatening damages, threatening legal recourse against the association, it is very important, one, that you contact the association's legal counsel so we can try to put out the fire as quickly as possible. And number two, based on the attorney's opinion, you may want to report that to the association's insurance carrier. The associations and condominiums are required to have not only general commercial liability policies, think slip and fall, right, damage to persons or property by virtue of the property condition, or directors and officer liability insurance. This director is harassing me. This director failed to comply with the law, and I want an injunction to stop them. In both cases, most of the time, depending on your insurance policy, there will be coverage for the cost of defense. But you only get that if, one, you timely put your insurance carrier on notice, and two, it's a covered claim. I have had many clients over the years go ahead and have a very valid claim where there should have been insurance defense and there should have been coverage for any damages. And they decided, we're going to try to put this fire out on our own. And they didn't contact me, and they didn't put their insurance carrier on notice, and they had a 90-day notice window. The failure to provide notice within 90 days means the policy will not kick in. Well, guess what they're doing now? We're now in a lawsuit. They're paying me out of pocket to go ahead and defend that case when it all would have been taken care of by insurance money if they have timely made a claim. So just very important, if you get a demand, get with your legal counsel as quickly as possible and get their opinion on whether it should be reported to the insurance carrier, because we may eventually need their coverage. Understand, just because you report it to the insurance carrier doesn't mean you're asking for the assignment of a claim or asking for insurance defense. You may just be putting them on notice that, hey, this is an issue that may come up, right? And I want you to know so that I've timely reported it to you. So just be aware of that. Let's talk about the flip side, resolving violations by homeowners. So this is generally going to go ahead and be violations of the rules and regulations, violations of the use restrictions, failure to maintain the unit. A lot of times we'll see people that leave units with the air conditioning off, and they become dilapidated, stuff like that. Where do we start? We usually, in most cases, start with a warning letter, either from the association if you're self-managed or the management company. Dear Mr. So-and-so, it's come to our attention that you are parking your giant truck in our small condominium spaces. XYZ of the declaration provides that no trucks are permitted to be parked at the association. Please remove the truck within 10 days, right? That's the warning letter that typically goes out. It's kind, it's professional, right? But it asks for compliance and gives a deadline. If that does not result in compliance, my recommendation is, instead of picking up the phone and calling legal counsel, is to proceed with fines or suspending the unit owner's common area use rights. So fines are the speeding ticket of the condominium world. Most of the time, those people who do not comply with the warning letter will comply when you start penalizing them monetarily. And so those can be up to $100 per day, up to a maximum of $1,000. It's a two-step process. One, the board of directors levies the fine. They send a letter to the homeowner stating, "Dear Mr. So-and-so, the board has levied a fine of $100 per day, up to a maximum of $1,000. Please pay that within a certain time frame. And if you would like the opportunity to appeal that decision, please do so by appearing before the independent fine committee or grievance committee, whatever you want to call them, and present your case." That grievance or fine committee will meet regardless of whether an appeal is requested. That's my thoughts on it. And they will hear and review the association director's decision. What evidence did they base that violation off of in the ability to levy the fine? They will then hear the homeowner's side of things. Maybe there's a justification. Maybe it's simply not true. I don't know. Maybe they have evidence that points it to otherwise. It wasn't them. But whatever it may be, that independent committee acts as an appeal to the board's decision. And their entire purpose is to afford both parties due process to make sure that we don't have a board that's going off and levying fines without just course. So that committee will go ahead and give a thumbs up, fine upheld in its totality, or they'll give the thumbs down and the fine is not imposed. They cannot modify, they cannot give a time for compliance. All they can do is give a thumbs up or thumbs down. Whatever the committee's decision, at the end of the day, they send a letter to the homeowner and to the board stating what their decision was. The third remedy, which is document specific, so this is not in the statute, is self-help. So some associations have a provision that say, look, if an owner fails to maintain their unit, the association may enter the unit, it will not be deemed a trespass, and they can remedy the violation and then charge the unit owner for the cost thereof. If you're thinking about exercising self-help, one, look at your governing documents. Is the authority in there to do that? If it's not, call the attorney. There's other ways that we can perhaps take a look at exercising self-help if it's an abandoned unit. There's a statutory provision on that. But look in your governing documents. And if there is the ability to do it, still pick up the phone and call the attorney, because there is a risk analysis that needs to go through. I've had two situations where a client went ahead and exercised self-help where they really shouldn't have. One, the homeowner answered the door and furnished a weapon. It was a gun. So the board members backed away, the sheriffs were called, and it was a whole debacle about whether he unlawfully furnished a gun, could probably have that gun, and so forth. So very scary situation. I never want to put my clients in that situation. Number two, I had another client. It was a villa type of community, condominium, and they were up on the roof cleaning a gentleman's roof when he was supposed to go ahead and take some action. And that gentleman decided to go out and knock down the vendors, the association's contractor's ladder, and then start pulling on the hoses that connect the pressure washer. In both instances, we were jeopardizing either my board members or the contractor's life, safety, and health. And I was very uncomfortable with that. So exercising self-help, it is a potentially available remedy, but I always like to go over those scenarios. Most of the time, if the unit's abandoned, I'm pretty comfortable. The unit, if the homeowner's there, it's a different type of story. So what happens if we do the warning letter, we do the fines, and we still don't have compliance? Well, hopefully you've whittled those down, right? The number of people that are still in non-compliance. Very rarely should an issue go to get to the attorney, but it does. There are people that simply should not be in a condominium. They don't understand that when you move into a condominium, you give up some of your rights. So the first step that I recommend is really two avenues. Eventually, we're going to end up in court. Eventually, I'm going to be asking the court for an injunction, right? Make this person get rid of their dog. We're a no pet community, something like that. But before I do that, I have to send a statutory demand for pre-suit mediation, or I have to engage in non-binding arbitration before the DBPR. This is a recent statutory change. It used to be that you just had to go to arbitration. And there was a way to get through arbitration pretty quickly, which I'll go over in a few slides. But most clients these days, I'm saying send the statutory demand for pre-suit mediation. That is a process by which we send a statutory letter. The homeowner has 20 days to go ahead and respond and select one of our 5 mediators that we listed. And then we sit down across from the table from them and see if we can resolve our differences. If we can, great, we draw up a settlement agreement, the problem is resolved, and if they breach it, we go to court and we enforce the contract, the settlement agreement. If we can't resolve it, we've checked the box, right? We can now file the lawsuit for injunctive relief. Very rarely am I recommending to clients that we go to arbitration. There may be instances where we think that's advisable, but most of the time with arbitration, one, you don't have the rights you have in court. Discovery is very, very limited. And number two is arbitration decisions are appealable de novo, meaning that no matter what the arbitrator decides, the losing side can appeal to court, and the local court cannot look at the decision of the underlying arbitrator as persuasive as to how that judge should rule. So instead of going through the whole arbitration mini trial process, for most clients, I say, look, we're going to end up in court anyways. So let's just do the demand for pre-suit mediation and go through that process. If we settle it, great. If we don't, we just go to court and pursue injunctive relief. When we talk about injunctive relief, that is a court order for the homeowner to comply. I'm requesting a court to find our restriction valid and enforceable, and that the homeowner is in violation. And then if they do not comply, they do not stop parking their truck there. They're required to get rid of the dog. They're required to go ahead and put away the clothes drying rack that they're hanging off the edge of their balcony, right? Those types of things. Then the court can hold them in civil contempt and put them in jail. I have 13 years of practicing. I've had 2 instances where we had to go ahead and threaten to put someone in jail, and 1 time we had to put someone in jail. So it's very, very rare that we get to that. Most cases are resolved far before that. But ultimately, that's where this ends up if we have non-compliance and the association wants to push it that far. So let's jump into non-binding arbitration or pre-suit mediation. This is only required for certain types of disputes. This is a statute you look at, 718-1255. Know that any covenant violations are going to fall within the definition of dispute, but I'll go to the next slide and show you what those are. So dispute is the authority of the board of directors under their governing documents, the statute, to require any owner to take action or not take action. That's a covenant enforcement dispute. We have a rule that says you shouldn't be doing this, you're doing this. Stop. The authority of the board under the statute or the governing documents to alter, add to the common area or common elements. So that would be a homeowner challenge to the board's decision. The failure of the governing body when required by statute to properly conduct elections. So that would be an election dispute. If someone says we didn't go ahead and properly send out the second notice of annual election, demand for pre-suit mediation required. They do not have jurisdiction, and these are the important ones, title to a unit, collection of assessments, so that's someone who doesn't pay, you can immediately go to the attorney, the eviction or removal of a tenant, breaches of fiduciary duty, so when a homeowner accuses the board of directors of breaching their fiduciary obligations to the community, and a claim for damage based on alleged failure to maintain the common elements. So that would be a property damage claim. Association, you failed to maintain the central water line that goes into the building. It leaked, caused damage to my floor. You don't have to go through arbitration or pre-suit mediation. Importantly, this 4th BCA case in 1998 says that a tenant dispute is not subject to arbitration. So that's the one we probably get most often. John, we have use restrictions in our community that pertain to who's allowed to be in a unit. If you're there over 14 days a year, you have to get approval of the association, much like a tenant. And this person has had this occupant in their unit for the past 6 months. What do? Previously, it was thought that you had to go ahead and go through arbitration first. But this case makes very clear that this is not a dispute under that definition. And as a result, you can go immediately to court on that type of use violation. So here are some arbitration rules of procedure. I'm going to kind of skip over these only because, 1, you can read them in the PowerPoint presentation, and 2, my recommendation is to not go ahead and proceed with arbitration. But feel free to dive in and take a look at those. Again, pre-suit mediation is the most cost-effective way to get you where you need to go. Know that if you do decide to opt for arbitration, you have to send a pre-arbitration warning letter, and it has to have these specific 4 items. You have to state that you went ahead and gave advance written notice as the nature of the dispute, the demand for relief and a reasonable opportunity to cure, and the notice of intention to file an arbitration petition or legal action. So in a context of an unpermitted pet, it would be, dear Mr. So-and-so, we represent XYZ condominium. Please accept this as notice that we believe you're in violation of the governing documents. Please remove the dog within 14 days. If you fail to do so, we're going to file a petition for arbitration. It can be that simple, but understand that when you go to arbitration, the first thing the arbitrator looks at is, did you comply with this? If you did not, the homeowner will never know you filed a petition for arbitration because it will be kicked out and dismissed immediately, subject to you sending a correct letter. And if you need to look up any of the items on arbitration pleadings themselves, there is a link to a website that has all the forms. Know that after the arbitrator reviews the petition and confirms that it has stated a cause of action, you send a pre-suit notice. There is an answer required from the respondent, typically in my case, the homeowner. And once they go ahead and respond, the case is typically set for a case management conference and eventually a mini trial. There is pleadings. There is the opportunity for mediation at the arbitration level. They do have a mediator that works for free, so that's always an advantage. But the process to get you to mediation within the arbitration process can be lengthy and costly. And the mediator declares an impasse. Rather than continue with the arbitration, the parties can opt out of arbitration. Understand that an arbitration order is a final order, but it is subject to an appeal to the local trial court. You have 30 days to do so. And one of the reasons that I find it very difficult is even if we win, we knock it out of the park, very possible the homeowner will appeal it and we have to start from square one. Know that you can recover your attorney's fees and costs in arbitration if you decide to proceed that route. My experience, the arbitrators generally cut the hourly rate of attorneys and the amount of time the attorneys have spent. Generally, anywhere between 70 to 80%, I would say, is a fair assessment of the actual attorney fees you spend in arbitration will be awarded back to you. And even that award on attorney fees is appealable by the losing party. So this deals with more aspects of the arbitration, and understand that the trial de novo does have consequences. That the party who files the complaint for trial de novo, the losing party at the lower level, shall be assessed the other party's arbitration costs, right, and expenses if the judgment upon the trial de novo is not more favorable than the arbitration decision. So this would be a situation where if you were unhappy, you went ahead and appealed it, all of the expenses at the lower court level or the arbitration level are compensable. And enforcement of arbitration orders. Let's assume we opt for arbitration. The 30 days goes and the arbitration order is not appealed to the local circuit court. At that point in time, it is an enforceable arbitration order. You still have to file a lawsuit in the trial court level, but all the court can do is enter an order enforcing it and enter an injunctive relief in your favor. But again, this is a rarity. Usually they result in an appeal or an alternative compliance. And here is the customer contact information if you need to contact anybody at the division. So last section, only 2 more slides. Let's talk about statutory updates. This is a big one. In the condominium world, 718.121 was amended to state that prior to sending a delinquent homeowner to the attorney for collection, that's where we do the claim of lien and the lien foreclosure, you have to send this letter and give them 30 days to pay in full. You have to use a form that substantively comports with the statutory form letter. So I recommend you copy and paste from the statute, fill in the due dates, fill in the money, fill in the unit partial, and send it out. Your management company, I know I've seen them at Vesta, they're perfect. But your management company should have a template. If you're self-managed and you have legal counsel, we certainly can provide them to our self-managed clients, but it has to be sent by the association prior to coming to our office. If you fail to do that, any attorney's fees that my firm incurs, you have to pay me, right? But you cannot recover from the homeowner. So very important this is done. Transfer fees, they were increased from $100 to $150 if authorized by your governing documents. So importantly, you can only do it if it's in your governing documents. It says if there's a lease, if there's a sale, you can charge a transfer fee. If it says that, you can now charge up to $150. Collections, it used to be that the first notice, the intent to lien letter, was 30 days for them to pay. It is now 45 days, which comports with the time frame in the HOA statute. And let me jump into that. Understand that what that now means is if we did everything as quickly as possible, homeowner doesn't pay their, let's do October 1st assessment, right? Well, it's not technically late until probably the 11th or the 15th day. Let's assume that we are Johnny on the spot and we send out that 30-day notice of delinquent assessments from the management company. Okay, it's now November 15th. They haven't paid the October 1st assessment. Let's assume on the 30th day, they forward to our office, right? And we send out the intent to lien letter. We send out that day. It's another 45 days. They still haven't paid. What are we in? We're in January 1st. They haven't paid October. Now they haven't paid January, right? We do the claim of lien. We send the intent to foreclose letter, which is a second statutorily required letter, right, from legal counsel. You have to wait another 45 days. The homeowner who did not pay the October 1st assessment they're incurring fees, right? But you can't even get to the point where you can foreclose on your lien until February. So I always tell clients, adopt a collection policy, right? Say when a homeowner gets to this amount delinquent or this many days behind, we start this process and it goes to this one, then it goes to this one, then it goes to this one. One, that ensures uniformity, and two, that ensures that if somebody's not looking at the AR report every month, that we don't miss anybody, that your management company has instructions about how to proceed when they reach that threshold determined by the board. 718-1265, we can now rely on the advice of health management officials in closing portions of the condominium property. So just know that is a clarification of emergency powers. And then the last item I'm going to give you is understand that as of July 1st, 2022, estoppel fees have increased, meaning what you can charge for the statutory estoppel. It used to be $250, now you can charge $299. If they wanted to expedite it, it used to be $100, now you can charge $119. If the account is delinquent, you can charge, it used to be $150, now you can charge $179. Our firm charges, if we are handling an estoppel, we charge the person requesting the estoppel the maximum permitted by statute. I see no reason why any client wouldn't choose other than to charge the maximum allowed by statute. There's costs that are incurred by the management company, by the lawyer, all of which we want to be able to allow you all to recoup. So with that being said, I am going to stick around for any Q&A that people have. You all can get some free legal advice. I'll answer any questions. If not, if you're going to head out, I want to thank you for your time today. Go ahead and understand that we will get you that certificate. I'm told by my assistant that those should be ready by October 15th. So if we get to October 15th and you have not received your certificate, email Brenda, email Kevin, email Vesta, or certainly email my office, and we will go ahead and verify that you attended and get you that certificate as quickly as possible. With that being said, I want to thank Vesta for the opportunity to appear today. I want to thank Kevin. I want to thank Brenda for allowing me to make this presentation, and thank you all for your time. Stay safe out there. Hopefully there was not too much damage, and hopefully we'll see you again next year. Thank you.
Thank you so much, John. I know we have a few questions in the chat. So the first question is, reserves do not have to be fully funded if the condo owners vote form partial funding, correct? Requires 51% to okay.
That was the old statute, and the new statute with Surfside is requiring full funding, no waiver of reserves. But again, we are waiting for the instructions from the division to confirm that that's the correct statutory interpretation for this upcoming year. I haven't had a client that has had their budget meeting yet, and the board has to propose fully funded reserves anyways. So I'm sure in the next 30 days, that issue is going to come up and we're going to have to start issuing legal opinions on it. The hope was the division would come out with their guidance prior to budget season, but we are running up against a deadline very quickly.
That is true. The next question, condo master insurance policy buffers budget, ? Inside, outside?
So 718-111-11 is the condominium insurance statute, 718.111 subsection 11. Take a look at that. I'm going to speak in generalities, but you should speak to your association's insurance agent because they will provide you the specific guidance. Most condominium associations drywall into the wall, association responsibility, part of your master policy. Paint interior furnishings, personal property of the homeowner. That is something that is covered by the homeowner's insurance policy. But good question.
Great. Brian says, thank you, John, for a very informative and educational session. I have two questions as follows. Number one, is it a recommended best practice for the treasurer to issue an annual year-end treasurer summary to all owners, which would include identification of future risks? And two, if such a report is issued by the treasurer, is it considered an official record under Florida statute?
So we'll start with the easier part. Yes, it's an official record. Any reports of the board members is going to be. In two, I think you have to look at it from a risk management standpoint. Anything you put in writing can be used against you, right? But I think it's important for the treasurer to communicate with the board and the membership to make them aware of the successes, the shortcomings in the current administration, and the risks that are upcoming. So I have zero problem at the annual members meeting of the treasurer issuing a report, the president issuing a report, any committees issuing reports, to keep the members apprised of what we're doing and risks we face. As a collective, we're all in the same boat in facing these risks. I'd rather have the discussion rather than to sweep them under the rug and let the next administration go ahead and try to fix it.
Got it. General pet policy, question mark. When are these put in place?
Pet policies, is that the question?
Pet policy.
Yep. So take a look at your governing documents and see if there is a use restriction that precludes pets. That's going to be your starting point. And if there is a provision that precludes pets, what does it preclude? And that's what we enforce. If it does not preclude pets and you want to preclude pets, you need to go and adopt an amendment to your declaration. Anytime you try to preclude pets, it's kind of hard to say, preclude pets, via rule, a board adopted rule, that's subject to a reasonableness review by a judge. And I could see a judge saying, well, why? Well, why do you need to restrict pets? Is it a health and safety issue? Versus if it's in your governing documents, in your declaration, the judge does not have the ability to look at that. They must enforce it as written.
Great. Scott says, awesome HOA and condo seminars. Thanks, Scott. We appreciate you being here. Thanks. Can we get copies of the PowerPoints? Yes, you will get copies of the PowerPoints when we send out your certification certificate. Do you have a table that compares the HOA versus condo statutes you covered?
I'm not aware of a table that covers everything. I am aware of some tables that exist. If you search Condo Blog, Florida Condo Blog, I know the law firm of Becker and Polikoff, which is a very, very firm. One of our partners in crime, so to say, in the field. I know they have a couple tables that talk about like election deadlines and notice deadlines that they do compare side by side. But it'd be pretty hard to compare one versus the other because they serve two different purposes. Mm-hmm. The condo statute is realistically, we're going to tell you what the legislature is going to do with your multifamily dwelling. The HOA statute, for the most part, is a gap filler statute, meaning that your governing documents don't speak to this. So this is what applies. So it defers to your governing documents. So it's kind of hard to have an apples to apples comparison, but I think that'd be a good resource. If you search Florida Condo Blog, it'll pop up as the first result. And then they have a search feature in there. I'm board certified for the past 5 years. I still like to peek at their stuff and see the insight that they have on stuff.
Okay, full funding of all components or just roof, paving, and paint?
This goes back to the Surfside legislation. I wish they would come out guidance because they could be so much more informative. So it's anything that has a end of useful life beyond 1 year, and it's above $10,000 in replacement costs. That is what the current statute provides. So if the association is required to take care of windows or hurricane shutters and the replacement cost is over $10,000, that's not done every year, that should be a component. Pavement, pool resurfacing, clubhouse. Every community is going to be a little unique, but you say, do we have a deferred maintenance item that the replacement cost is above $10,000 and lifespan is beyond a year? If it is, it should be in our reserve study. And it should be fully funded, at least on the board's initial budget. And based on where we end up on the Surfside legislation, I'm thinking my opinion is going to be that pretty much we're not going to waive anymore or partially fund.
What happens if you can't form a fine committee because few owners want to be involved? Great question. Great question.
You can't levy fines. It's terrible. Like, it's
terrible.
Terrible. So I always try to, depends on the size of your community, right? 500 unit condominium, realistically shouldn't have a problem. 12 unit condo, right, where everybody knows everybody and they gossip every night with drinks by the pool, it's a little tougher. But you have to have at least 3 independent members sit on that fine committee, and they can't have any relationship to the board members.
What are you recommending to clients on addressing the increased use of units for Airbnbs when charters are old, they do not address limitations? This is from a board member, I think, in a community I used to manage.
So it's a tough world out there. So my experience, Airbnb, VBRO, all these rental sites, you can send them letter after letter after letter to take down a listing. They won't care. It's like throwing stuff in a black hole. It's a waste of time. So what do? You go after the homeowner, the owner of the unit. You can only go after them if you restrict Airbnbs, home swaps, or something like that, and look at your lease terminology to see what you all restrict. If they are in violation, I would start hitting them up with fines for every day that they're in violation of the minimum lease term, no transient tenants, right? Failure to get approval of the lease. Every single time I would hit them up. And if there's still an abuse after you've racked up all those fines, I would probably get in contact with legal counsel, and I would probably pursue a statutory demand for precinct mediation. The goal here is make the homeowners feel risk, make them spend the money to go hire an attorney, because at least the people I've talked to, those are profitable, right, entities to run a transient Airbnb out of your unit. And so you really got to hit them hard that it's no longer a sound investment for them. And then all of a sudden they say, it's not worth it. I'll move to somewhere else.
If this is the community I'm thinking of, there is no language in their documents regarding lease restrictions. So they would have to do an amendment, correct?
Correct. Yep. And understand that an amendment regarding lease restrictions is prospective only to those people who voted in favor of the amendment and those people that acquire title after. So it may not fix your problem. So probably some ways we can strategize about that, because I've had some clients run into that issue. But at the same time, it's going to be an uphill battle for you.
If the reserves are inadequate, is the normal way to get them fully funded a special assessment?
Yes. Another item that I've had clients do is you can't go ahead and borrow money to fund reserves, but they've said, look, we're behind, but we now prospectively are going to fully fund reserves. Well, there's going to be a shortfall at the end of the day. And I've had some clients talk to go out and get a secure line of credit to say, look, we know we're going to be $100,000 short with fully funded reserves at the end of the day. We're going to have this line of credit, not that we're going to borrow the money and put it in reserves, but we're going to have it available so that if something comes due early, right, we know we'll have access to capital to go ahead and get it done. And hopefully we can take some of those reserve components beyond their planned lifespan, and that will allow us to build up enough reserves to fully fund the replacement without tapping into the line of credit.
Who is responsible for the air conditioning drain lines, since each owner is responsible for maintaining them and they drain into the main line?
Oh boy, I got a case on point. I got a case on point. So there is an arbitration case out there. And the arbitration case provides that a homeowner is responsible up into where you get into a common drain line. And then after that, it becomes the association's responsibility to go ahead and do it. Here's the problem from a practical standpoint. Where did the clog occur? It's almost impossible to prove that, right? And so you have the homeowner who's saying, association, you need to do it because it occurred in the common drain line. We'll prove it, right? And the association is upset and they say, you know, you got to go clean out your drain line, right? Well, the clog's in your drain line, not mine. So it becomes an issue of proof. So what do I recommend to clients? I recommend that you send out requests for all your homeowners to remind them to have their ACs checked yearly, and to see if you can set up with a local AC contractor a little bit of a maintenance plan for your community, where they'll come out, they'll give everyone a discount, and they will clear everyone's drain lines at the time. Again, the homeowner doesn't want to comply, we're going to have to deal with it on a case-by-case basis, but for the most part, I've seen success with that approach.
Great. If a fine committee voted not to fine you, can a board member fine you anyways?
No, nope, there's no appeal from the fine committee declining to enforce a fine.
Okay. And Ken just wants to confirm what you said earlier. He said full funding is required after 1/1/2024. Is that what you said?
Yes.
Mhm.
Yep. And there's also requirements if you're over 3 stories, you have to get an engineering report. Again, our firm is currently working on an e-blast that we can send to all clients. But again, it's a cat and mouse game, or I guess the chicken and the egg. We don't want to send it out and then have the DBPR come out with guidance that differentiates from our opinion. So the good news is there is a condo seminar next week where all the nerds in the state get together, and the DBPR will be there, and we will all raise our hand collectively and say, can you please give us guidance on this? And hopefully within the next couple of weeks, we'll have something.
And then you and I are going to try and plan another webinar to cover some of that. So we'll be
Correct.
sending those invites out.
Absolutely.
Get that scheduled.
Please attend.
Last question is regarding Airbnb. What if the owner was grandfathered in before HOA docs changed?
Then you can't restrict it. That's the problem with the way the condo statute is written. Is it's prospective only. And so if that owner is in there and they did not vote in favor of the amendment, that amendment is not applicable to them. And so it becomes a question of whether there's other ways to go ahead and approach it. Talk to your legal counsel. We'll see if we can come up with something creative.
Great. Okay, I'm scanning through one more time. I don't see any more questions. I just want to thank John for spending half the afternoon with us and shedding light on all things board certification. I, as a CAM, always learn something. It's very valuable information that you share with us, so we really appreciate it. And I want to thank everyone that's attended our course today. And we will send you an email with the PowerPoint and some other additional information and your certificate within 15 days or so. Stay safe out there, and we appreciate you very much. Thanks for attending today, everyone. Have a great
Thank you.